To begin with, I'd like to acknowledge that I am hosting this meeting from Naarm, Melbourne, the lands of the Wurundjeri people of the Kulin Nation. I'd like to extend my respect to elders past and present. It's wonderful to see a great turnout today, and I think I know why. We've got a terrific lineup of speakers and a very pertinent and fascinating topic to discuss. But I'd also just like to acknowledge that everyone who's on this call has sent through their details. We now have the SAP Research Network directory up and running on the Peter McMullin Centre's website, so you can see your name listed there. And if you haven't yet sent a link, be it LinkedIn or any other kind of website presence that you have that you'd like to have linked as your profile on that directory, I'd really welcome you to send that through to Marika as soon as possible, in case anyone who's looking for a scholar that they'd like to work with or whose brain they'd like to tap, who looks up our directory, they have an easy way to not only contact you, but also read a little bit about your background. So following the meeting, please do send through a link to any website presence that you'd like us to link to. So to today's meeting, and I'm really happy to say that this was a topic that received quite a lot of support. And I think the way we've been working to sort of circulate topics of interest and to get sort of votes on them is a good way even moving forward. But looking at statelessness and issues of legal identity in the context of armed conflict is something that is a topic that is increasingly becoming more and more relevant as the number of very public conflicts or media reported conflicts are dissected in ever more detail. We get to know the different aspects of those conflicts, including in relation to nationality issues. But a quick bit of research prior to this showed that the International Committee of the Red Cross in 2024 actually reported that there were over 120 armed conflicts around the world involving over 60 states and 120 non-state armed groups. So it's little wonder that we now have quite a number of researchers who are looking more carefully into this topic and how it intersects with issues of nationality and statelessness. Of those 120, just under half have been classified as international armed conflicts, and this large number of armed conflicts has remained relatively stable over the past few years. However, how situations of armed conflict impact the nationality of armed and non-armed actors before, during, and following war has to date remained an understudied issue. We're therefore very lucky that in our own SAP Research network community, we have leading scholars who are examining issues of nationality, statelessness, and legal identity in the context of war and its aftermath with us today. So we're going to have three presentations, and I'm going to introduce the presenters all at once now, and then let them get on with presenting their fascinating research and the questions that it's raising with us. So to kick us off, we will have Andrea Immanuel, who is a doctoral candidate, soon to be done, I think, at the Peter McMullin Centre on Statelessness. She's also a teaching fellow at the Melbourne Law School and formerly an assistant professor of legal practice at Jindal University in India. She's a qualified lawyer from India, and she's worked as a refugee status determination officer in UNHCR in India as well. Her doctoral research is on the right to nationality during armed conflict. Next, we'll have a presentation from Jyoti Singh, who is a doctoral candidate at the Faculty of Law at the University of Delhi. She is a qualified Indian lawyer and has worked for the government of India on pertinent issues related to international law as a legal consultant. She is also visiting faculty to the Indian Society of International Law, and her doctoral research is on cyber warfare and use of force in international law with special reference to India. And last but not least, we have Marika Sosnowski. She is an Australian qualified lawyer, a postdoctoral research fellow at Melbourne Law School, and a research associate at the German Institute for Global and Area Studies in Hamburg. Her work sits at the intersection of sociopolitical legal anthropology, and her primary research interests are in the field of critical security studies, local and rebel governance and legal systems, and particularly around issues of citizenship and belonging, with a geographical focus on Syria. So without further ado, I'll now pass over to Andrea to start her presentation. Thanks, Andrea. Over to you.
Thank you so much, Radha, for that introduction. I hope you can hear me well. Um, yeah, great. Thank you, Marika. So it's so good to be here and meet everyone. And thank you so much for your interest on the topic. I've been given about 15 minutes to speak. Let's see how I go. It might be a bit shorter, but happy to answer questions in the Q&A that follows after all the three presentations. So, as Radha mentioned, my PhD thesis is titled The Right to Nationality During Armed Conflict. So, in my PhD, I look at different armed conflict situations. I sort of map what happens during armed conflict. I then look at the grant and deprivation of nationality and how international law regulates the grant and deprivation of nationality. And then I use an interdisciplinary lens to see if we can better understand the right to nationality and how it could protect individuals and individual interests during armed conflict. But today, what I'll touch on is a bit of the legal methodology that's involved in this research, and what I feel could be, the way forward in terms of the legal approach. A lot of what I would present today is coming out in the form of a blog commentary that will be out sometime this week, and I think most of you would have signed up for the Critical Statelessness Studies blog, and you will receive you will come across this commentary. So as Radha mentioned, there's a number of armed conflicts that are ongoing, 120 ongoing armed conflicts. And actually, if you see the UNHCR Global Trends Report, which contains, the number of stateless persons, where they come from, a number of statelessness issues are either tied to armed conflict, with people being displaced because of armed conflict, stateless people being displaced because of armed conflict, or there are ongoing armed conflicts in regions where stateless persons are located. So this should prompt us to think more about what are not just the solutions, but what are the approaches to address statelessness in these regions. So my first point that I wanted to highlight is really for us to understand, and when I said I'm going to look at methodology or explain about methodology. So to understand what really goes on during armed conflict and who are the players, what are their goals, how does nationality play a role in this, and how does it affect individuals? So what is this connection between nationality and statelessness, and how does it link to armed conflict? So firstly, sometimes people might be stateless and they may arrive in countries where there's ongoing armed conflict. So an example of this would be Palestinians in one big example of this, but there are a number of other examples. So for instance, Palestinians arriving in Syria or have lived in Syria for years, they have left their home territory or home country because of ongoing conflict, cannot return to their place of origin, and are going through the problems that statelessness raises in their situations of displacement. The other sort of situation that could be is that during the course of armed conflicts, statelessness may arise due to displacement, loss of documents, or due to state action. And the state action aspect, I'll come back to it. But during the course of conflict, and again, Syria is a good example of this, where people have lost documents and are in displaced contexts, either as refugees in other countries, unable to establish their identity, or unable to possess legal identity documents because they've either lost those documents or they're not able to receive or access these documents by returning to Syria. A third example would be about how armed conflict could affect people who have dual nationality or multiple nationalities, thus leading to a violation of the right to nationality without the result being statelessness. So my talk today is titled Nationality and Statelessness During Armed Conflict. So there are instances, and I will touch on one such instance, which is the Ethiopia-Eritrea conflict, where there were people who are suspected of or accused of holding both Eritrean citizenship and Ethiopian citizenship. And then they were stripped of their Ethiopian citizenship by the Ethiopian government. So on the face of it, we don't see statelessness arising because they are presumed to be Eritrean citizens. But this we cannot ignore this sort of context because it's still a violation of their right to nationality. And the other context, the fourth context, is when nationality of foreigners becomes a way to target civilians. So nationality, bearing a particular nationality, could lead to harm to individuals, or being a foreigner during an armed conflict could lead to harm for individuals. So an example of this is Ivory Coast. So in Ivory Coast, the people from the northern part of the country, called Northerners, were considered as foreigners, and this was used to target them. And also foreigners who were actually from other countries were also targeted because they were foreigners. And that's just one example of how foreignness becomes an identity that's imposed on individuals. But again, nationality could also be an identity that individuals carry and could become harmful for them during armed conflict. And finally, the problem that a state may not exist or may not be globally recognized. And so statelessness is literally the outcome of the absence of state, or statelessness. So two examples of this is Palestinians. So a lot of states now recognize Palestine as a state, but a lot of states also do not recognize Palestine as a state. And even if Palestine is recognized as a state, a lot of the institutions of Palestine are still under the control of Israel. So again, this becomes a problem of statelessness for individuals. And the other example is that of Western Sahara, where actually Western Sahara territory is non-self-governing territory. That means that this territory and the people of the territory have not achieved independence yet, and the decolonization process is ongoing. So the reason I refer to all of these examples, just to give you a broad picture of why we should be concerned about this issue of nationality and statelessness during armed conflict, but also to draw your attention to the fact that we can't simply take solutions or approaches that are used for peace times and sort of adapt them or tailor them automatically to armed conflict situations. Now, in this regard, this is where I mentioned about methodology. So first, it's important to understand who are the players in armed conflicts. First, it could be states who are represented by their governments. Then there could be occupation, and occupation is generally categorized under international law as international armed conflicts. So there's an occupying power, which is typically a state, being in control of territory of another state. And so there you have two players. One is the occupying power, which is actually a state. And then you have the state, which is legally speaking the sovereign authority over the entire territory. And that is the government of the occupied state. Then finally, you have armed groups, and armed groups fighting against each other or fighting the government. So these are the players in armed conflict. And I raised this point because each of these parties to the conflict, and that's how we call them in international humanitarian laws, parties to conflict, have very specific goals. So for instance, governments might want to protect the existence and the continuation of the state. And this is usually threatened during armed conflict. So that's why during armed conflict, concerns about national security could preoccupy governments. When it comes to occupying powers, they may have territorial ambitions. Annexation could be on their minds. They might already be treating the occupied territory as annexed territory. To continue controlling the population for achieving their goals in the conflict. They might want to institute a new government for the state and therefore continuing the occupation. So it's important to understand what the goal of the party to the conflict here being the occupying power is. And finally, armed groups might be fighting against government, either to overthrow the government or to oppose the government to meet their demands, or they might be seeking legitimacy, might want to extend their territorial control. So these become the goals of armed groups. So in relation to all of these goals of the parties to the conflict, nationality plays an important role as a tool. And this is what I call as instrumentalization of nationality. So parties to the conflict might instrumentalize nationality through the grant of nationality or through the deprivation of nationality. For what purpose? For all the purposes that I just mentioned that the parties to the conflict might have. So automatically, parties to the conflicts begin questioning who belongs to the state, who does not belong to the state, who can remain in the territory, who has to leave the territory, who can produce or perform military service on behalf of the state, and who's loyal to the government or the armed group or the occupying power, as the case may be. Now, given this context, with this context, we can look at how international law regulates nationality. Now we know, and this is often discussed by international law scholars working on statelessness, that international law considers nationality as a state power, and it's considered as a reserved domain power, which means that every government of the government of every state has the right to decide who the state's nationals are. But apart from this, we also know about international human rights law, which limits this reserved domain power. Now, when it comes to armed conflict, with both of these rules in mind, that is international human rights law and the reserved domain rule, it's also important to bear in mind international humanitarian law. And why? This is not because international humanitarian law has rules specifically regulating grant and deprivation of nationality. It does not. Except for a few exceptions. It doesn't really say who's supposed to give nationality, who can deprive nationality. All of that is the work of international human rights law. But what are the powers on a specific party to the conflict? What are the obligations of a specific party to the conflict? How should occupied territory be treated? How should armed group controlled territory be understood? All of this, IHL or international humanitarian law can provide light on these topics. So what usually scholars working on armed conflict do, international law scholars, is to read international humanitarian law with international human rights law. Both of these frameworks are understood as doing different things, but having the same goals. So they read it side by side or together. And with that, they're able to find out how international law regulates nationality. And this is the approach which I have found helpful in understanding how international law regulates nationality during armed conflict. So I've often found that I'll have to look at a particular situation, a particular armed conflict, from the perspective of an IHL scholar, and then from the perspective of a scholar working on statelessness, looking at human rights law. And this kind of these different lenses can provide us a holistic understanding of how international law addresses these conflicts or nationality during these conflicts. I just finished by emphasizing two cases where this sort of approach has not been taken, and that has led to catastrophic results. So the first is the Nottebohm case before the International Court of Justice, and very common case discussed a number of times since 1955. But the problem that the court missed in the Nottebohm case is that it did happen in the background of the Second World War. Nottebohm was seeking protection because he had naturalized during Second World War. And the reason he had naturalized was to protect his interest as a German national, and German nationals would otherwise be treated as enemy nationals during conflict. This point was actually noted by the International Court of Justice, but the court took a very different approach. It noted this point and used it to say that Nottebohm was abusing the nationality, the international legal order to achieve his goals. But what the court failed to note is the impact that armed conflict can have on individual interest and how the individual might have to navigate legal systems creatively to protect their interest. The second example is it's an arbitral decision by the Eritrea-Ethiopia Claims Commission. In this case, in this decision, the commission actually noted that that Ethiopia had not followed due process in depriving individuals of their nationality. Yet, the commission said that Ethiopia was facing a wartime situation, and this could constitute an exception to follow due process guarantees. The Commission did not elaborate how. So if the Commission had actually looked at international humanitarian law and human rights law, it would have been able to understand what are the due process that applies during wartime situations. I'll stop here just to recap. It's in terms of how we look at the situation and the ways forward. We need to remember there are multiple players to the conflict. We need to remember that there are different goals that each player has in the conflict. Each player might use nationality as a tool or a weapon to advance their goals. And we should be able to navigate the legal framework by understanding this conflict, this context, and devise solutions or approaches during armed conflict as well as post-conflict. I look forward to hearing your questions, and also would love your comments on the article that will be published. Thank you.
Thanks very much, Andrea. Fantastic. It was really good to have that set out as the starting presentation. I think you covered a lot of sort of foundational issues as well. And I think both Jyoti and Marika's presentations will actually complement what you've said really, really well. So thank you very much. I'll now pass over to Jyoti. Thanks.
Yeah, thank you so much, Professor Radha. And thank you to Andrea as well. It was really a very nice presentation. And she has just created the background of what exactly is this context of statelessness and armed conflict, and what are the theoretical issues which are there to be highlighted. So very nicely explained by Andrea. So I'll start from where Andrea has stopped. So it is a kind of paradoxical situation for the combatants, I mean, the members of the armed forces and the stateless fighters. So when the members of the armed forces go and serve the country, and when the stateless fighters serve to their own causes, the difference is very pertinent. So the kind of rights and protection the members of the armed forces get, and the kind of protection which the stateless fighters get, is drastically different. So that's a very interesting point which I got to explore during my research on cyber warfare, because there was a point where I came to the point of statelessness being faced due to the armed conflict. And when I was in Melbourne, I had brief interaction with Andrea and Jade also regarding the statelessness because of the armed conflict. So from there only I carried this throughout, and then I thought of like researching more on the issue of stateless fighters. So what I have researched is this, that the stateless fighters are not having the rights and privileges and protections which a prisoner of war gets. Means when you are a member of an armed forces of a country, you have got the privileges or the protections which are extended to the prisoners of wars when you are captured by the other country. But that's not the case with the stateless fighters. So I think I don't have to explain who is a stateless fighter, because stateless fighters are the people who come from another country and then they join the group of non-state actors. If they join the group of non-state actors, and if they join the country's army, then they have a different status. But that also is a very cumbersome, researchable question, if I can say so, because when you join a state's army as stateless person, then you have to, the articles on state responsibility for wrongful acts, ILC articles will come into picture. So then everything will have to be seen from the perspective of the state responsibility. So in that, there are many things like, accountability of the state, responsibility of the state. So generally, what we see is that the stateless persons do not join the country's army. So pertinently, they join the non-state actors group, and they have a conflict with the country. As we call that non-international armed conflict. So there are two types of IHL conflicts. One is international armed conflict and one is non-international armed conflict. So they are generally part of the non-international armed conflict. And once they enter the country, they somehow get entangled into the issue of the group of non-international armed conflict people, and then they wage a war against the state. So NIAC comes into the picture. So after discussing everything, I have to just explain this also, that stateless fighters are not same as the foreign fighters. So many of you would have read about the foreign fighters in the context of Ukraine versus Russia war, and Ukraine categorically invited the foreign fighters in to fight the war with Russia. He kind of notified a notice. He kind of took out a notice, and he asked the neighboring states, including Germany and European states, to send their fighters, and they should be part of the armed group, and then they will be fighting with the other side, which was Russia. So they are known as foreign fighters, but that category is different because that they fight for the country, they come to the country, and they are having a country. I mean, they are citizens of another country, but their role is very restrictive, means they are foreign fighters, not stateless fighters. So that also is another aspect which needs to be researched and debated upon maybe in the next rounds of meeting. But right now, coming to the stateless fighters, so I don't think I have to explain about the 4 Geneva Conventions, Geneva Convention 1, 2, 3, and 4. I hope that we all are knowing about the 4 conventions. So one is the protection extended to the wounded armed forces members. Second is the protection on the land, and second is the protection extended to the wounded and sick persons who are on the sea. Third is the protection extended to the prisoners of war. And fourth is the protection extended to the civilians, so who do not take part in the armed conflict. So these are the 4 conventions which were drafted to give protections when there is a war or warlike situation. So when it comes to stateless fighters, they are covered under Common Article 3 of all the 4 Geneva Conventions, and also the additional Protocol 2 of the Geneva Convention, which came in 1977. So what kind of protections they get under the general clause or the Common Article 3 is that very general kind of protection, that is human treatment. So they should be given medical facility. They should not be exposed to torture. They should be given, judicial support. And of course, they will be allowed to meet their families. So these are the basic human kind of treatment which is extended to them under the Common Article 3 of the Geneva Convention. And same kind of protection is extended little elaborately under the Additional Protocol 2 of the 1977. But when the members of armed forces get arrested, or when they are captured by the other side, the states, they capture them and they become, they have the status of combatants, means they are properly armed fighters belonging to the armed forces of the country. So that's why they get the status of combatant. When you commit, you are being guided by 4 principles. That is, you are being guided by a respondent superior. So one commander is guiding you. Secondly, you are having one distinct symbol. That is, you are having an uniform. Third is that you are carrying openly a weapon. And fourth is that you are free to do the kind of, the hostilities which the armed forces do in a kind of warlike situation or war. So these are the 4 criteria to become a combatant. So the stateless fighters actually do not belong to the category of combatants. And that's where the paradox comes into picture. Because they are not combatant, they are not extended the protection of being a prisoner of war under the Geneva Convention 3. So they are actually treated, they will be given the human treatment under the Common Article 3, but at the same time, they will be not given the protection of being a prisoner of war when they are captured or when they surrender to the state. So the thing is this, that they will be having very restricted kind of protection. Means they won't have any diplomatic protection, means they won't have consular access. Secondly, they will be not having the privilege of being repatriated. So they won't be repatriated to their country of origin because they are stateless. And third is that they will not be having a very elaborate fair trial. So these are the privileges which they won't be having. Plus the meeting with the family will also be very restricted. So they will be primarily treated as terrorists and criminals rather than being treated as prisoners of war. So that is the difference, and that is the paradox which comes into picture. And that is the difference between the armed forces, members of the armed forces when they are arrested, and the stateless fighters when they are arrested, or when they leave their weapons and they surrender. So that is a very peculiar kind of protection, which is not, the stateless fighters do not get the status of a combatant and prisoners of war, and that's why they are treated very differently when compared to the members of the armed forces. So having said that, now we can see that in the context of ISIS and Palestine and the Rohingya refugees. So when there is in the all three categories, we see that there are primarily stateless fighters who are participating in the non-international armed conflict. But at the same time, they are not being extended, as I have discussed, that they are not getting the protection of the combatant or prisoners of war. They are treated very differently. They are not repatriated to their country of origin. They don't have the right to meet their diplomats. So all these things are not there. And I can tell you the example of one case I can cite here, one case of Shamima Begum. So she was treated as a terrorist captured in Syria. She was only 15 when she intruded in the territory, and then she was captured by the forces, and then she was put in the camp. If I can take 1 or 2 minutes extra, I'll just add that case. And she was kind of captured, and she was being tortured, and she was exposed to all kinds of brutality. So then she appealed in the courts in the United Kingdom, London. And there she said that I should be also getting the protection of being a prisoner of war. Why am I being treated as a terrorist? Because I was stateless. I intruded into the territory of Syria. And somehow I was, taken into the prison, and then I'm exposed to all kind of brutality. I should also be getting the protection of a prisoner of war. I should be getting the privilege of meeting my family. I should be given a fair trial, all those things. But unfortunately, her appeal was dismissed, and she was only treated as a terrorist by the judicial authorities in United Kingdom also. So this is how they are being treated. So coming to the suggestion, which I want to put it here, is this, that there are soft guidelines, soft rules are there in international law. One is Turin rules, which was drafted by the UNSCR. And the UNSCR drafted it in the context of the people who get captured during the armed conflict only. So it was more to do with the stateless people only who are captured in the armed conflict. But that's non-binding. That's a kind of soft rule in international law. So that's why not many people are aware of those kind of rules. So according to those rules, fair trial should be given to the prisoners who are taken into custody when they are captured by the state. And then they should be given diplomatic protection, diplomatic access, consular access, and then they should be repatriated in a respectable manner. So all those kind of things, rules are there in that Turin rules. So something like that, because this is a very dichotomous situation, because one side you are treating the members as prisoners of war, but at the same time you are treating these stateless fighters as terrorists. So there is too much of a stark of a difference. So that's where my research comes from. And yeah, so this is what I wanted to present to the audiences in the meetings. Thank you so much.
Thanks very much for that, Jyoti, and thanks also for highlighting issues of terrorism and deprivation of nationality, which we've touched on in previous meetings as well, but it is relevant, of course, in this context. When we come to Q&A, I'm quite curious to understand how this topic came up in the context of cyber warfare, where perhaps it's not so much territory-based, but we'll come to that later. But thanks very much for your presentation. Lots of questions to come out of that. I'll now pass to our third and final speaker, Marika. Thank you.
Thanks, Radha. Thanks, everyone. It's great to be with you here and see so many friends and colleagues. Thanks for joining. I'm on Wurundjeri land here too, actually. So this research that I want to talk to you about today comes out of about sort of 5 years or so of working specifically on legal identity documents during conflict, mostly to do with the case of Syria, but that's kind of broadening out now as part of the larger project I've been working on as part of my postdoctoral fellowship, which is kind of broadly called The Legal Afterlife of War and Revolution. So for that, I work with 10 other scholars who are sort of working on that topic in different contexts. So that ranging from Cyprus to Colombia to North Korea, all sorts of different contexts. So we're interested in, I guess, how the law is understood at a really everyday level after experiences or because of experiences of war and revolution. So my contribution academically to that project really has been to do an ethnography with five different Syrians I've known for around 10 years about their experiences of basically the law and violence, particularly at checkpoints, and how that relates to legal identity documents. So I'm going to share one of those examples with you in this talk. But first of all, I just wanted to tell you some of the literatures that I draw on to sort of make the claims that I do. So the first literature really is this literature that has to do with the kind of interconnected nature and the intersectional nature of the law and state violence, basically. And that literature basically says that you can't have one without the other. You need violence or the threat of violence to make the law function and be effective, basically. So there's a vast literature on that. I draw on some of that literature for this work. The second literature is to do sort of very broadly with, I would classify it as kind of remembrance studies or trauma studies. Again, very vast literature. What I do with that is think about it not so much as these experiences of the law and violence being traumatic necessarily, although in some cases they are. Sometimes I don't think they rise possibly to the level of being traumatic, but they're certainly complicated experiences, complicated emotional experiences that stay with people long after those experiences are over. So I use the work of Birgitta Stamper-Holst, who's also part of the project with me. She works on authoritarianism and how authoritarianism and the ideas around authoritarianism travel with people when they leave, for example, a state like Syria, and how that authoritarianism becomes manifest in their daily lives. And thirdly, I use the literature on checkpoints, specifically Omar Siri, who's got a great PhD thesis where he talks about checkpoints as being spaces that aren't necessarily axiomatic. So he says checkpoints are really an unsteady collection of practices, relations, and feelings. And I guess to Siri's understanding of checkpoints, I add that they're also an unsteady collection of the law, basically, and the way the law and legal identity documents work at places like checkpoints. And the other person who writes really well about checkpoints is a Tunisian author called Ahmad Macharek, who sort of talks about checkpoints as being not necessarily what we automatically think of when we think about checkpoints, although they can be, but checkpoints have become these places that have become disassembled. So they can happen deep inside, for example, a state's territory, and not necessarily just on the borders of a state or be state run. They can happen anywhere where there's an interaction between a person and kind of an authority figure. So for example, to do with getting civil registry documents or legal identity documents, or to do with kind of interacting with the state in some way, or the state bureaucratic system. So that's the literature I draw on. So what I want to share with you now is just one of the examples from the Syrians that I spoke to over many years now. I'm going to use the example of Marda. That's a pseudonym for a friend of mine who I was talking to. This story comes from a dinner we were having in Berlin a number of years ago, and she was telling me that around 2013, which is 2 years into the civil war and revolution in Syria, she was walking with her boyfriend past one of the many checkpoints that the al-Assad regime had at that time in Syria set up all over the country. Her boyfriend had an ID card that said he was from Douma, and Douma at that time was an opposition-controlled area. So the boyfriend was stopped actually all the time at checkpoints, and his ID was checked because specifically he came from this opposition area. And she tells me in most cases he would be allowed to go on. But on this particular occasion, when they were walking together in Muhajirin, which is a suburb in Damascus, they were stopped at a checkpoint, and her boyfriend was specifically singled out by the guards at the checkpoint, who started to talk about arresting her boyfriend mainly just because that he was from this opposition-controlled area of Douma, which they had read on his identity card. So Marda was quite scared about this eventuality, so she interjected into the sort of guards' discussion about the arrest, "Huwa min jamiatna," which basically in Arabic means "he's with us." And so Marda, she speaks with a nondescript Arabic accent, which in Syria is usually called a white accent. And this means that it's not distinct to a particular sort of sect or a particular place, but it's usually considered to be the accent of people that's come from Damascus. But because the guards at the checkpoint had seen her ID card too, which made it known to them that she wasn't in fact from Damascus, she was from Latakia, and she was an Alawite, which was the sort of Latakia and Alawites were the main supporters and the main region that supported the regime of Bashar al-Assad before the fall late last year. The guard looked at Marda kind of with disgust, like, "What are you doing, Alawite lady, working with this guy, this Sunni guy from Douma, this opposition-controlled area?" But then the guard told Marda's boyfriend, that just because of her, they were going to let him go this time. And Marda and him walked away, and after they left, Marda started to cry, and she explains, she said this, "I did it to help him, definitely, but I felt so ashamed that I had to do it like this. Someone who is not religious, that doesn't acknowledge that she belongs on that basis to a group of people," she's talking about the Alawite sect here, "I don't deny it. I was born to this. But it was so hard at that moment to feel like that." And then she tells me almost 10 years later in Berlin, she's having to renew her German visa to stay in Berlin. And she explains that when she goes to the Ausländerbehörde, the German Immigration Bureau, she becomes overwhelmed with a complex ill-at-ease feeling, not dissimilar to the same feeling that she felt at the checkpoint in Muhajirin. And here she says again, "It was not smallness as much as feeling like someone is controlling your life. Either they will decide to give you this or that document. They will decide to take you away or not. For instance, for some Syrians, sometimes an official will spell your name wrong on your documents. This means you then have to go and ask for this to be changed. And depending on the situation, it can be like your whole destiny is under the control of this one official who is managing these documents. And they can fuck you up, absolutely. And this is the reason why I still feel sometimes, even in Germany, it's a different regime entirely. But with all these regimes, it feels like they have to discipline you. Sometimes I look at myself and say, like, what the hell? What am I doing linking these two different experiences? But I think at the end of the day, you don't get rid of it. So I think the two lessons really that I take from what Marta and the other Syrians have told me, or different stories that have a similar kind of flavor, is really that these experiences, these kind of experiences that Marta has had and these encounters at checkpoints are really highly unpredictable. And they really induce complex feelings in people of unease and insecurity. And I think this is like trauma in a way, but maybe it's not necessarily exactly the same as trauma. But like trauma, it can stay, these experiences of the way the law and violence work and legal identity documents work at places like checkpoints can stay and be held in the body and outlive the temporal boundaries of that actual event that happened, for example, in Muhajirin in Damascus. The second is, I guess the larger point is that these particular complex feelings come about largely as a result of the way that the law and violence function at places like checkpoints, where agents of the state, whether they be guards, border security, bureaucrats, can use the law, so defined, in various ways backed up by violence. Thanks, Radha. I'll leave it there. Looking forward to questions too.
Thanks, Marika. Sorry, I thought you were going to go on. I was looking forward to yet another story that was fascinating. Thanks very much for providing that other quite personal perspective to complement the other two presentations, and also sort of speak a bit more about the aftermath of the actual conflict as well, and those ongoing kind of acts of violence. Three fantastic, thought-provoking presentations. Thank you very much. And I just want to say, how lucky are we to have such experts in our midst who can speak to so many aspects and facets of the topic at hand. Thank you very much, Andrea, Marika, and Jyoti, for taking the time and for answering so many diverse questions today. And thank you to everyone who's part of the network for joining and for stretching this topic in all different directions as well. It's been really stimulating. We'll finish up here and we'll be in touch as always to let you know about the next meeting, which will be next quarter. It'll be the last one for the year. We'll also circulate, I think for the first time, the recording of this meeting, which will also be posted on the SAP Research Network website on the Peter McMullin page. So thank you everyone for attending today, and very much look forward to being in touch again. And just to let you know and remind you that Andrea's blog that relates closely to her presentation today will be published this week as well, and you will be notified about that. Thanks again, everyone. Have a great rest of your week. Bye-bye.